Good afternoon, everyone. We're so happy to be presenting a timely panel entitled Immigration Policy and Practice During the Coronavirus Pandemic. This is a panel sponsored by the ABA Commission on Immigration and Section of Civil Rights and Social Justice, and it's one of a number of a series of rapid response webinars on the COVID-19 pandemic. We are actively planning additional COVID-19 programming on a variety of issues. Please do visit the American Bar Association website for updates on these programs. Before we go into the real substance of our program today and also talk a little bit about how we're going to work it, first I'd like to introduce Judy Martinez, who is the president of the American Bar Association, who's going to make some introductory remarks. We're so happy that you're with us, Judy. It really shows the commitment of the ABA and your personal commitment to these issues. Thank you for being with us.
Oh, thanks, Denise, and thanks to all the panelists for taking time out of your very, very busy days to come together and impart the knowledge and experience that you have. Let me thank the ABA section on civil rights and social justice, the Commission on Immigration, and the many other sponsors who are making this webinar possible. It's a part of a series, as was Denise just noted, and we appreciate all of the aspects of the series because it's touching on so many emerging issues that are coming forth as a result of the pandemic. The ABA has long been active in the immigration-related policies arena as well as in activities, including our immigration justice programs at the border in Texas and in San Diego. And during the pandemic, our efforts have even expanded more and they've become critically important to those whom we serve. For example, at the end of March, the ABA called on the Executive Office for the Immigration Review and Immigration and Customs Enforcement to take steps to further protect the health and safety of individuals working in and appearing before the immigration courts that remain open during the COVID-19 outbreak. We believe that additional uniform measures are needed to ensure the protection of individuals while preserving non-citizens' access to legal representation and information. And the ABA has called upon the Executive Office of Immigration Review to withdraw a proposed rule that would increase existing fees dramatically, and for the first time, include a fee for filing a defensive asylum application. We're also encouraging and urging the Executive Office for Immigration Review to temporarily suspend all immigration court hearings and appearances for unaccompanied children held in the Office of Refugee Resettlement Custody. Critical and emerging issues like these and others are being addressed by a cross-disciplinary group of individuals who care, like all of you care who are listening today. And much of that work is going on by the newly formed ABA Task Force on legal issues arising out of the 2020 pandemic, and all of the ABA entities that are represented on that task force, as well as the other organizations outside of the ABA that have come together under the ABA's convening power to work together in order to reach solutions. We invite you to visit the task force's website at americanbar.org/coronavirus task force. As the voice of America's legal profession, the ABA is proud to offer these educational programs and resources on a range of implications coming out of the pandemic. We invite you to utilize them, to learn from them, and to share your insights with your communities. And we urge you to join us in the ABA as we go forward in this work in the days and months and weeks ahead. With that, I'll thank again all of our panelists for coming together on this, what we know is a very busy day, and turn it back over to Denise, our moderator. Thank you all for your leadership.
Thank you again so much, really, for being with us today. All right, so during today's program, we do encourage you to ask questions of the panelists, and we will get to those towards the end of the session, although we're going to try to end the session on a note of asking each of our panelists to provide their strongest recommendation for how to address the current situation, but there will be a period for question and answers. If you could use the Q&A function rather than the chat function. That will make it a little bit easier for us as we manage the panel. That should be on that control bar that you have down at the bottom of your screen, usually at the bottom of the screen as an attendee. If you don't see the controls, it may just be that you need to jiggle your mouse or your keyboard to make sure that the screen isn't idle. We also wanted to let you know that we will be recording and sharing a recording of the program with everybody who has registered so that it can be sent out to your networks. And please do feel free to leave us feedback or ask questions after the panel as well. With that, we're going to jump in to today's program, which again is entitled Immigration Policy and Practice During the Coronavirus Pandemic. I'm going to very, very briefly introduce who the panelists will be, but they will mainly be talking about the important work that they are doing. Just before getting into that, I want to provide a very quick word of framing, which is just to say that this pandemic really has affected every single aspect of immigration law, practice, and policy. Today's panelists will largely be focused on border enforcement, detention, removal issues. This is sort of the enforcement side of immigration practice because these are areas that have been very deeply impacted. But it is not to say, and Judy mentioned this as well, that the pandemic and the responses have not also impacted what we call the services side, petitions for family members, business visas, and other aspects of immigration process. But there really can be no doubt that as to the enforcement side, border enforcement, detention, removals, that the responses have been in a way a deepening of policies that already were in a pattern of exclusion and marginalization, and the newer policies have really just made that all the more dramatic, exacerbating existing problems with access to justice, violations of due process, and the like. In another way, the responses to the pandemic have also really highlighted some of the serious existing problems that were there in terms of an incredible backlog in the immigration court without efficient systems in place to be able to deal with it and to provide people with fair and adequate adjudications of their claims. Dire problems with access to counsel, insufficient numbers of attorneys to represent those who are undergoing removal proceedings, grave problems with immigration detention, and very exclusionary policies at the border that limit access to asylum, for example. So those issues undoubtedly will be highlighted by our panelists today, but I just wanted to provide that brief framing. So we're going to start with Dr. Eileen Marty, who is has been gracious enough to join us, is a medical professional, an MD, who works on infectious diseases at Florida International University, and she's going to be sharing with us an overview of some of the ways in which the nature of this pandemic influences and intertwines with immigration policy and practice. Then we're going to hear from Alice Farmer, who is a legal officer with the United Nations High Commissioner for Refugees office here in the United States and has been looking at responses at the border and elsewhere. Then we will hear from Fatma Maruf, who is Professor of Law and Director of the Immigrant Rights Clinic at Texas A&M University, rival law school to my own. I co-direct the Immigration Clinic at the University of Texas Law School. So after Fatma is going to be speaking more about removal cases, immigration court cases, and the challenges that are presented for individuals undergoing those removal proceedings, as well as the attorneys attempting to represent them. And then we will hear from Dr. Dora Shriro, who is a special advisor to the ABA Commission on Immigration, and who is a well-known, long-time detention and prison reform expert and advocate with special knowledge about immigration detention, who will be speaking about the immigration detention context in this pandemic and what could be done to address the unique issues arising. And finally, we will hear from Fermin Vargas, who is the senior staff attorney at the ABA Immigrant Justice Project, which is out in San Diego. And he's going to speak about his work in detention and addressing some of the challenges that are raised sort of on the ground and in terms of sort of greater impact strategy and litigation efforts to try to address the needs of detainees. And in the process of making those presentations, I realized that I didn't properly introduce myself. So let me just very quickly do that. I am Denise Gilman. I'm a clinical professor and co-director of the Immigration Clinic at the University of Texas School of Law, and I am also a member of the ABA Commission on Immigration. With that, Dr. Marty, could you start us off?
Yes, I'm going to share my screen now. Hopefully it'll work. If not, I've sent you my slides so that you can share it. Can you tell me if everyone can see my slides?
Yes.
Is my screen visible? Because I can't tell.
It is. Thank you so much. Yes.
Okay, so knowledge is power. Bottom line is the more we understand about this virus, the more you know how to apply all the various principles that you guys have to apply to do the right thing by immigrant rights and what's going on in detention centers. So we'll begin by noting this human cell, and all these little yellow dots are, of course, our very famous virus now. So what is this virus? Let's understand it for a second. It belongs to this great big order of viruses that do something really weird. And this is important for you guys to know, believe it or not. It does this really weird thing of having nests. That's why they're called nido, from the Latin word for nest, nesting their genetic information. And in that group, we have a whole bunch of different kinds of viruses, including this kind of virus here that's actually seen in insects. But the family we're interested in is coronaviruses. And the specific kind of coronavirus that we're interested in is of the genus beta coronavirus and of this particular subgenus. And here's the thing that people don't understand. This SARS-CoV-2, this virus, is the same species as SARS-1. It's a subspecies difference. So they are the same species, except that it behaves, because it's a slightly different virus and is of a different subspecies, it behaves far more dangerously than SARS does in terms of its transmission. We actually figured out that this virus is most similar to that virus that had already been found years ago in a bat, the horseshoe-shaped bat. And specifically, we talk about one specimen from that bat, from one cave in Yunnan, that's 97% the same as the virus that is now causing COVID-19, the SARS-CoV-2 virus. So that, just to put it in perspective, it was found here in Yunnan, and here is where Wuhan is, near the U in Hubei province here, more than 1,000 miles away. And so this is a virus that has been known for a while. It was actually described a long time ago, this particular version of the SARS virus. And it's a virus that we know hops around from humans to animals, believe it or not. And in fact, we know that the receptor, the doorway through which, the lock, if you will, through which the virus enters our bodies is identical or nearly so to that of felines, many different cats, domestic cats and wild cats, as well as ferrets, macaque monkeys, and chimps. So we're still exploring how this virus is going to affect the animal kingdom as well. If you look at what happened, this has been a huge rise in cases from when we first started understanding this virus. The World Health Organization had its first meeting on this, international meeting, on the 14th of January, at which time they already expressed the possibility that this had significant human-to-human transmission, and they certainly were worried about healthcare workers, just as we were for SARS and MERS, two related viruses. Now, the SARS virus, we knew was not highly transmissible between people, but this one, it so happens, is. And in fact, on the 16th of March, so on the 14th of January, we had 41 cases known in the world. By the 16th of March, the rest of the world had overtaken China in terms of cases. And now today, a month later, we're looking at over 2 million cases in the world. And we're often talking about what's going on in the US as a very high incidence of this disease. But notice that Europe actually has many more cases, and their case fatality rate is about 10, which is much higher than our case fatality rate, although both Europe and the United States are doing much worse than Asian countries are in taking care of the overall case fatality rate. But also that has to do with how we're testing and who we're testing and who we've been testing, because we get a skewed result if you don't test the people who are less severely ill. In the Americas specifically, and I think this is particularly interesting for immigration law, again, we're seeing still the highest numbers of cases in the United States overall, and the paths for importation throughout the Americas, for Latin America, the United States has been a great source of the virus for Latin America. Spain, Italy, France, United Kingdom, being way up before you ever get to China in terms of where these cases originated from, the imported cases. And we've done significant studies on how long these last on surfaces. And again, that's very relevant to detention centers because obviously there's a lot of commonly touched areas, and someone who's positive can most certainly spread the virus to others. So we know that the stability of this virus is about 7 days in respiratory secretions, because the secretions have with them sugars and mucin and salts that help the virus survive for a long time on surfaces if they're not cleaned. It can also stay very perfectly alive, and this is not just detected by RT-PCR, but actually grown and shown that the virus is alive 4 days in undiluted urine, and it can actually last as much as 4 days in diarrheal stool alive. And mind you, people who are positive and recover can be shedding virus in their stool for 30 days. And then that stool in turn has viable virus in it for another 4 days. So those are very significant numbers as we see them. Now, of course, these viruses are sensitive to cleaning. Household bleach will kill it in 5 minutes. 70% ethanol will kill it in 10 minutes. 100% ethanol, 5 minutes, and it's gone. So having wipes available for cleaning surfaces to the inmates is a way of reducing the transmission if you allow them to have those kinds of things with them. An important concept is the infectious dose. The infectious dose for this virus has now been determined, and we talk about infectious dose, that means the bolus of a virus that leads to disease. And we talk about an infectious dose 10 would be that bolus of virus that 10% of the population, if they encountered that low amount, would still get sick. A 50% infectious dose is that slightly greater amount that would lead to illness in 50% of the population, and so forth, you understand. So we generally, when we talk about infectious dose, we're really referring to the infectious dose 50. For SARS, it was about 100 to 150 plaque forming unit. For this new SARS-CoV-2, the agent of COVID-19, it's about 90 plaque forming units. So you need a lower dose in order for it to spread. The serial interval is also a lot shorter for this virus. In other words, the time between when a person gets contaminated and when they start shedding virus and are able to infect other people. But that is impacted by what infectious dose the person received. That's another reason for cleaning, because if you keep that infectious dose that somebody receives as lower, it's going to take longer for that serial interval. It's going to take longer for the incubation period as well. But the fact that it has a short serial interval and its serial interval is lower, smaller than the interval of time for incubation is why we're seeing so many pre-symptomatic people shedding virus, people who have no idea that they're sick because they have absolutely no symptoms or extremely mild symptoms that don't alert them to the reality that they're infected. Moreover, we know that there are people who stay subclinical, who are never symptomatic. And some of the early symptoms would be the loss of smell that we see in as much as 85% of people of certain groups now. So this is why it's spreading so fast. In addition, the amount of virus in the upper airway initially on this virus is 1,000-fold more than we ever were able to detect in SARS or MERS. So they have a lot more virus to shed, whether or not they're showing symptoms. So the whole goal then is to be able to get out of this mess, to be able to get out of our homes and go back to a normal society, is to get rid of the reproductive period, the reproductive number, which is the amount of people that are infected for each person that has virus, which in the initial studies in Asia were about 3.9, close to 4, in other words. With public health measures, we were able to bring it down to around 2 in the United States, a little bit over 2. But that's not good enough. To get rid of this virus, we have to bring the reproductive number below 1. So the components that have to do with this reproductive number is the duration of the infectious period, the opportunity for contact, how many people are you around, and the transmission probability. If you're around somebody that has this virus, how close are you to them? And are they shedding virus at the time? Are they coughing? Or are they contaminating the surface around them because they have dirty hands after going to the bathroom, for example? So to try and reduce those things, to reduce the duration of infection, the only things that exist for any type of agent would be an antiviral, since it's a virus, or a post-exposure vaccine. We don't have those yet. We're working on it, we don't have them. But we can work on the opportunity rate or the contact rate and the transmission probability, and that's what we've been doing with shelter in place, limiting mass gatherings, hand hygiene, proper PPE, room hygiene, the idea of wearing masks outside when you have to go out, if you're out and about, even though you have no symptoms, in case you're the one who unwittingly has the virus and is shedding it. The most important thing that we have to do is testing, testing, testing. Not just of the symptomatic patients, not just of the ones sick enough to go to hospital, but of the immediate contact of every single person that is positive, which means you have to test the households. And we're trying desperately to get our leadership to understand how critical that is, because that's what's worked in South Korea. If you look at the numbers in South Korea from March until now, they've barely increased their cases compared to the rest of the world. Why? Because they're doing that kind of contact testing. It's a critical thing. Germany is doing better than the rest of Europe because they're doing that kind of contact testing. That's what we need to do to actually get out of this safely as soon as possible. The last part of the equation is that susceptibility probability, which is how good a host you are for the virus. So by having healthy living, eating well, exercising, and sleeping, you become a worse host. You become unpleasant. You have a better and stronger immunity. If you are happy, if you amuse yourself, if you're not depressed, if you do not smoke, all those things make you a less desirable host and improve our odds of getting that reproductive number below 1, which is what we need to get back to normal. We know that the cases, 80% are, and this is true here in the United States as it was in China, as it is in the rest of the world, roughly speaking, 80%, which with half of those being mild, not so mild, I might add, and the pneumonia is a significant one, but not significant enough to require hospitalization. Then, of course, we have our severe and critical cases, and I won't go into that too much. I will talk about children. There's a study that came out just a few days ago from the CDC comparing children and adults, children being anybody 18-year-old or younger, and that's again important for these detention centers. And notice that their symptoms are different. The prominent features in children are fever, cough, headache, sore throat, and muscle pain. They very few, only about 13% have the shortness of breath that we see more commonly among adults. But overall, children tend to be subclinical. And yes, we're seeing more cases in children, but the percent of children infected is the same here as it was in the rest of Europe and in Asia. It's a little bit under 2%. But obviously, mathematically, if you have more cases, that 2% becomes a bigger number, a bigger total number. So in terms of what can be done in correctional facilities, detention centers, you have to set up screening and triage. You have to assure that there's personal protective equipment for staff and inmates. You have to train people to use them. We recommend surgical masks for the inmates. They're less surgical masks are not as uncomfortable to wear as N95s. N95s are incredibly uncomfortable. You have to assure heavily touched areas are cleaned at least 4 to 8 hours. And you have to set up, especially in these ward situations, COVID positive and COVID negative areas. And you can put COVID positive mild cases together and then monitor them for any changes in their symptoms, taking temperatures twice a day, monitoring their actual manifestations. So if they need higher level of care, you can put them there. That's not ideal, but that is something that is being explored in a lot of places, and it's a scientifically reasonable thing to do, even though, as I said, it's not ideal. But obviously, if you have a designated ward for COVID-19, then these heavily touched areas have to be cleaned much more frequently than in the other areas. Of course, you want to identify your high-risk individuals, the people. CDC has greater than 65, but the science actually says greater than 60 is where we really ought to look. So that's why I put greater than 60. The underlying conditions that are most important are the cardiovascular disease, the high blood pressure, and it has to do with this ACE2 receptor that the virus uses. The chronic underlying lung diseases, diabetes, cancer, obesity, chronic kidney disease that needs dialysis, liver disease, and the immunocompromised. What really we ought to do is perform IgG and IgM, that's immunoglobulin serologic tests on all these individuals if you're going to keep them in detention, and separate those who are positive from those who are negative. And that is also something that has to be done for the staff as well. And then, of course, you want to establish those separate communities. And as I said, you can group them. What are we doing right now in medicine to try and fix all this? Well, we're working on better diagnostic tools of all kinds, improving our specimen collection, which is one of the reasons that we are seeing with the RT-PCR nasal 30% false negative. So people who actually have the infection are coming up negative at a rate of 30% because of specimen collection, huge issue. So we have a lot of goals in that regard to try and fix. Treatments, of course, we're looking for antivirals, not just antivirals to treat people who are ill, but also perhaps an antiviral that can substitute for a vaccine by being a pre or post-exposure drug. And of course, so we're also, in terms of prevention, looking for that vaccine, but that's really hard to make for this virus for a lot of complicated immunologic reasons, and any ways that we can to reduce the transmission potential. And also to understand this relationship between humans and animals so that we don't wind up having a second event, not because of humans, but because of animals. And that completes my part of what I had to say. Thank you.
Thank you so very much for all that important information. Several people have asked about availability of the slides, and understand that you are comfortable with us sharing those after the program. So they'll be up on the website for the program, and we are recording all of this, and that will be up as well. So thank you very, very much. Alice, do you want to jump in with UNHCR's perspective?
Sure. I'm very grateful to Dr. Marty for the presentation, and I would just start by noting that some of the other panelists will address detention issues, so this will all sort of knit together, although this particular transition isn't I'm going to switch us over to talking to the border for a little minute so that we can just consider what happens to asylum seekers and refugees arriving in a country at this point in time. So I'll go over 3 areas in about the next 7 minutes. And the idea is to go over the US border very quickly, then look at the international legal position that UNHCR is urging states to use at this point, and then to look briefly at what we know about other countries' practices. So starting with that first point, the US borders, everything I say here on the US borders is publicly available information. This isn't a UNHCR specific position. Much of it you might already know from news reports or NGO publications, but I'll round it up very fast. On March 20th, the government issued an IFR and a CDC order. So that CDC order gave CBP, Customs and Border Protection, the authority to expel people at US borders. Previously, CDC had the authority to examine and screen things at US borders, but not to expel people. So this is a fundamental change. What this means pragmatically is that asylum seekers either at the ports of entry or between the ports of entry can no longer register a claim for asylum. They will be immediately expelled. Mexicans will be turned around and sent back to Mexico. Some other nationalities will also be turned around and sent back to Mexico. That includes Hondurans and Guatemalans. Others can be rapidly processed and flown home very fast. So for those of you familiar with the immigration system, the asylum system, this is all outside of the Title VIII Immigration and Nationality Act. This is all going ahead under Title 42, which covers some public health legislation. This process includes unaccompanied children, it includes families, and there is a very cursory screening for fear of torture, but there is no longer a screening for fear of persecution. And so that torture screening is not broad enough to catch asylum seekers and refugees. Using CBP's own public statistics for March, we know that from when this went into effect on the 21st of March until the end of March, there were at least 6,000 expulsions under this, under the Title 42 procedure, so outside of the normal immigration framework. And like I say, this isn't a UNHCR study. This is just what's publicly available information. So clearly that's a big shift in the US border. Let me turn quickly to UNHCR's positions. On March 16th, UNHCR put out a new paper. This is a globally applicable paper called Key Legal Considerations for Access to Territory in the context of the COVID response. We've been making that paper available pretty widely. I think it was sent out with some of the materials for this webinar, and we'll certainly make sure to follow up with you all afterwards with that link. This paper goes into some very, it reiterates some basic ideas of international refugee law that we've followed for 50 years or so. First, that access to territory is a fundamental principle. It's the basic first step in finding refuge. And so if you can't even get into someone's country, you can't claim for asylum there. So without access to territory, the problem is that refoulement occurs. So that means that people are sent back to persecution, torture, or death without any opportunity to seek protection against that behavior. So it's been a long-standing principle of international law that refoulement includes turning people away at the border. It doesn't just mean people who are already in the country who we send out without proper screening, it includes people at the border. And so our March 2020 paper reaffirms these principles in the context of COVID. And we take that basic idea that you must be able to access territory in order to uphold the right to non-refoulement. That applies even in the context of a public health emergency like this. We accept that states have the power to regulate their borders, but the ways that they implement those powers cannot prevent people from seeking asylum. And in order to protect against refoulement, you need to come up with an effective way to identify those with a fear of persecution. So states at borders have a duty to make independent inquiries as to whether or not someone needs protection. And for those of you on the webinar who've ever done border work, you will know that CBP asks a series of 4 questions to elicit whether or not people have fear. And if they do, then they're passed into the credible fear screenings. That is no longer happening. So at this point, there is no independent inquiry as the person's need of protection. So all of these principles sound somewhat familiar, but it's worth emphasizing that we can't diverge from these principles in a public health emergency. Under international law, states can take certain measures to manage public health risks. Absolutely, that makes sense. But such measures cannot be discriminatory. So you can't discriminate a certain group, for instance. You can't say, we will leave our borders open for tourists, but we will close them for asylum seekers. That is not a legitimate move. The measures you take must be necessary and proportionate and reasonable to the aim of protecting public health. And so what that ends up with is basically screening travelers is perfectly acceptable. Screening asylum seekers is acceptable. Using quarantine for a certain period is also perfectly acceptable. But expelling people at the border is not acceptable. You cannot derogate from the right that people have to seek asylum, or which is a corollary of the right to protection from refoulement. A quick word on detention, because I know that's an issue that we hope to talk about a lot on this panel. In general, international law has a fair bit to say about immigration detention, namely that it can't be arbitrary or indefinite, and the same remains true under COVID. In a public health emergency, states can restrict people's movement, but they must do so under the auspices of a legal framework that has independent review and procedural safeguards. This also comes up in the key legal considerations paper that we'll make sure everyone has access to. So a quick segue for about 30 more seconds into how that's playing out globally. UNHCR works in about 90 countries across the world, and we are all monitoring on a day-by-day what's happening with the border closures, border openings in all over the world. It's a massively dynamic situation. But what we do know is that some other places similar to the United States have closed borders, but still allow essential travel. So for instance, the EU is refusing entrance of non-EU citizens into the EU bloc unless they have an essential function. And they're defining that to include, as an essential function, the need to seek international protection. So asylum seekers may still enter. There are parameters around that for the individual countries of the EU, and I do not want to take us down the rabbit hole of EU migration law. But it is to say there is a permissible way to deal with your borders. Canada has introduced border restrictions as well. They have carved out a particular exception for unaccompanied children. That is also a good practice, and something that we're not sure, we know is not happening on the US-Mexico border. I can go into some more country examples, perhaps in question and answer, but I want to close with one thought, which is that when UNHCR, we think about this problem right in the immediate now, and then 6 months or a year down the line. One of the pragmatic issues with stopping asylum seekers at the border is it puts them into orbit, and what they end up doing is going somewhere else to try and find a country of asylum, and then somewhere else, and then somewhere else. That's bad public policy to be encouraging that kind of migration when we've got a global pandemic. And second, it's actually also bad public policy from a global level to be sending people home or to be causing further degradation of very weak states at this point by spreading a virus further through those countries. And so we think 6 months down the line, a year down the line, we're still going to see massive migrations. We're not doing, like, closing the borders now not only violates people's rights, but doesn't help in terms of how we get a better handle on some of the global problems underlining all of this. Denise, I'm sorry, I took perhaps 30 seconds too long. Back to you.
No, that was great. The last 30 seconds were important, so thank you for that. All of it was important. We're going to turn it over to Fatma now, and I believe you're already going to address a couple of questions that have been raised by listeners, by participants about what is happening with removal proceedings, with hearings in these cases, and specifically what is happening with asylum seekers who, before the border completely shut down, were here. Are those cases going forward? What's happening?
Yeah, sure. So I'll start with that court status. Currently, only detained cases are being heard. So in terms of people who are applying for asylum for the first time, who have already been in the US, for example, and are applying to US Citizenship and Immigration Services, that agency is currently closed. It's accepting applications, but as far as I understand, they're not actively working on them right now. But the court system, the immigration court system, has suspended all of the non-detained cases, including asylum cases, through May 1st. I think that will likely be extended, but we can't say for sure. The detained cases are still moving forward. And one of the problems that that May 1st deadline is posing for attorneys is that they're still trying to prepare for those non-detained cases that are scheduled for May and thereafter during the pandemic, which is quite difficult. Several immigration courts have already closed completely due to COVID infections and related reasons. And I think about 8 others are currently open only for filings, but are not hearing cases. So it has dramatically affected the immigration court system. And every day we're seeing more cases of positive COVID tests among individuals in immigration detention and among the staff who work at those detention centers, which you'll hear more about later. In terms of how the Executive Office for Immigration Review, or EOIR, which is the agency within the Department of Justice that includes the immigration courts and the Board of Immigration Appeals, in terms of what they have done, currently they have established a temporary email filing system that is new. Some courts already have electronic filing, many don't. So for those that don't have it, they can use this email filing to avoid submitting paper documents. In addition, many of the courts, I believe 38 courts last time I checked, have issued court-wide standing orders specific to the COVID-19 pandemic. So those are some specific instructions from those individual courts that address things like telephonic appearances and requests for continuances to postpone hearings. One of the issues is that there's no consistent guidance from EOIR, so it's been court by court. And in some places like Dallas, where I am, we have 3 orders by 3 judges within the court. We don't even have a court-wide order. So there's a lot of variation across the country that makes it hard for attorneys to have a clear understanding of what's going on. Telephonic appearances for attorneys is one of the biggest issues because many attorneys are afraid to go to court right now because of the high volume of interactions that happen in court, all the surfaces that hundreds of people are touching, make it a high risk area. In fact, the CDC recommends alternatives to in-person court appearances in order to help reduce the risk of COVID-19 infection. But it's a dilemma for attorneys because appearing by phone instead of being in person is not as great a form of advocacy for your clients. There's many disadvantages. Your client often can't see you. Well, if you're on the phone, they definitely can't see you. Even if you're on a video camera, they often are not able to see the attorney, rather they're able to see the judge. So it's a really lesser form of representation. You can't also observe what body language either your client or the judge or opposing counsel has. But many of these temporary standing orders that courts have issued are helpful in that they waive any requirements for a written motion to appear telephonically. Some of them do impose other conditions or constraints, though, that raise due process concerns, like, for example, not being able to submit any documents after the close of a hearing if you appear telephonically, or saying if you miss the court's call for the telephonic hearing, then you must appear in person afterwards. And that's difficult because courts will often call hours after the scheduled hearing time. And so if you don't happen to be by the phone anymore and you miss the hearing, you could be required to then go in person. In terms of witnesses appearing in court, this is also creating an issue for them. Some of these COVID-specific standing orders are prohibiting witnesses from coming, so they limit the people who can be present in the courtroom to certain individuals that don't include any witnesses. And others specify that witnesses have to submit written affidavits or declarations. And that undermines, due process and statutory rights to present and cross-examine witnesses. So really, witnesses should be allowed to appear in person or telephonically if they desire. In terms of sort of rescheduling cases and asking for postponements or continuances, again, we see wide variation across the courts. I think this is a rarer form of standing order that sticks with the regular immigration court practice manual, which generally requires any filings to be done 15 days ahead of time. But many others do make emergency sort of accommodations during the pandemic and I saw one that allowed 15 minutes in advance of the hearing, to request something, or in a much shorter compressed time period. Bond hearings right now to get people out of detention should be the highest priority, but courts are not all prioritizing them. In fact, I don't think most courts are prioritizing them. So for attorneys, I think getting clients out is the top issue. And in order to get a client out who was previously denied bond or to get a chance at another bond hearing, you normally have to show a changed circumstance that would justify the court looking at the bond issue again. So advocates are arguing that, COVID-19 should be considered a changed circumstance that would allow a second or subsequent bond reconsideration hearing. In terms of access to counsel, this is another major issue. Because attorneys working with detained clients can only meet personally with their clients in the detention center, and those are not easy to access right now. Until recently, the guidance from ICE, Immigration and Customs Enforcement, was to bring your own personal protective equipment, PPE, if you're an attorney wanting to meet with a client in detention. And most attorneys, I don't think, have PPE. Certainly most pro bono attorneys don't have PPE. And can't get it at this time, really. So that was creating a big obstacle to in-person visits. Now ICE has changed its guidance to say that representatives have to undergo the same screening as staff, but it doesn't specify what that screening involves. It appears it may be a temperature check. But so going in person is dangerous. At the same time, remote visitation, meaning telephonic or video visitation with individuals in detention, also remains extremely challenging. There are actually very few legal phones available in detention centers. So in some facilities, you have a few phones for 3,000 people or 2 phones for 1,500 people, which is really absurd and makes it impossible to try to for all attorneys to communicate by phone with their clients. And on top of that, there are often strict time limits on phone calls, for example, 30 minutes, where you can't really prepare a client to testify in that amount of time. And on top of that, there are privacy and confidentiality issues. So if the individual in detention is in a common area, they have no privacy. There's other detainees walking around, and there's often the confidentiality that the attorney needs for attorney-client privilege is missing. So there's so many challenges to remote visitation as well. In terms of filing deadlines, attorneys and advocates have requested extensions, but again, there's variation from court to court right now. I've seen filing deadlines move to 2 days, 5 days, 10 days. It really varies. Some courts like Conroe, Texas, is not accepting any filings over the bench anymore, so no in-court filings except by pro se litigants. And advocates are generally calling for all of these deadlines to be extended or told. Exceptional or changed circumstances is often a reason to extend deadlines. And so arguing that COVID-19 is such a circumstance is a legal avenue to get those extensions. In terms of people who've tested positive for COVID-19, the courtrooms, we've definitely seen at least 3 courts close for 1 day because there was a report of a positive test, but there's really no guidance as to what courts should do when somebody tests positive. What is the appropriate amount of time to close? There's not even guidance available to the public, at least, on what cleaning procedures are taking place in courts, how you know, what proactive steps are being taken to prevent people from getting contaminated in courts. So we really do need more guidance from EOIR on some of those issues. So I will conclude there. Thank you.
Thank you so much, Fatma. There were a couple of comments that I think are so closely intertwined that they're worth just mentioning on your important point about the difficulties in phone communication with detainees. Commentators noted also that the calls tend to be recorded. They're not actually confidential calls. In theory, you might be able to set up a confidential attorney-client meeting, but good luck getting a hold of somebody in order to schedule such meeting. Has that been your experience?
I would say confidentiality is one of the biggest issues. I thought I touched on that, but yes, I mean, even when they tell you it's a private line, it may not be a private line, in addition to just not enough supposedly private lines being available.
And I actually wanted to confirm something with you in terms of video interactions, at least here in our area. There is no potential for attorney-client preparation by video, nor is there really the possibility for attorneys to appear by video remotely into court. The only real use of video is so that detainees will not be brought in person into the courtroom. So it's sort of a marginalizing mechanism, but not a facilitating mechanism of allowing those who otherwise wouldn't be able to appear at all to appear by video. It's only used where those who are in custody could be brought in, but instead are appearing by video. Is that mostly your experience as well?
That is correct. I believe there was some guidance on March 18th from EOIR that I believe, and I'm not 100% sure, but recommended that courts try to make VCT technology available for attorneys. But I don't know of any courts that currently have a way for attorneys to appear by video, only telephonically.
And then somebody noted another piece, which I know you've noted elsewhere, which is that some of those standing orders also include language about disallowing objections to evidence.
So if you read it, the ones that I have seen, and I've read a number, I've read all of them at some point, but they basically say on the sole basis of not having been able to examine the document in person. So you're not waiving any objections, but you're waiving the ability to say, I object to this document because I was on the phone and was not there in person and couldn't examine it. So it's a little bit more limited, but I could certainly see it becoming an issue as well. So there's several different conditions. There's 3 that are pretty standard, including that one.
And any prognosis as to when we'll know whether the non-detained dockets will open back up?
I don't know. I think it'll probably track how long a state of emergency is being declared, state by state and nationally. I think that's been sort of, I don't see it ending May 1st, which is in 2 weeks.
All right. Thanks so much. All right, so we're going to turn to Dr. Shriroa now and delve a little bit more deeply into the detention issues.
Good afternoon, everyone. It's really a pleasure to be here. I'd like to start with a fast frame of reference for everyone. You may have heard it said, and it's true, that ICE is the largest system of incapacitation in the United States, which is really quite a statement. And although the numbers have been dropping recently, there are still about 33,000 individuals that are detained today, an average of 55 days, which is difficult under any circumstances. And under these extraordinary circumstances, you can imagine how terrible it is for them. These folks are held in, excuse me, over 200 facilities around the country. And the year to date, almost 140,000 individuals have been detained by ICE. So it's not just the large number there on any day, but over a relatively short period of time, just how many are in the system. One of the things that's striking particular to this conversation, and we always make a point when we talk about what a facility ought to be and where it ought to be and what it ought to be doing, is that over a third of all of these 222 detention facilities are outside a 25-mile radius of a hospital with any ICU beds whatsoever. And so if somebody needs treatment, the difficulty in securing it in the facility as well as outside the facility is increasingly difficult to encounter. One of the anomalies in the ICE system in comparison to correctional organizations, whether they be jails or prisons, is that there is a lead health organization that is part of ICE. It's called the ICE Health Services Corporation, IHSC, which is difficult for me to say on a good day. And they staff 36 of those 222 facilities. So it's 15% of the facilities. It's about just short of half of the entire detained population. But they also promulgate the policy for healthcare. But the policy that they promulgate, and this is really a core concern when it comes to managing COVID-19, is that it's really two systems. When you look at all of the information that has been issued specific to this pandemic and its control, is that they make requirements of their own system, but only recommendations for the rest. And I want to talk for a minute or two about that. It's a great concern that you have one system, everybody under the authority of that organization, but depending on which facility you're in, the conditions of your detention can really vary appreciably, and it can have a significant impact on your health, as we're coming to see today. The initial plan, which is just as recent as March 6th and has changed several times since then, set forth some extremely rudimentary screening procedures and a few guidelines for isolating and monitoring detainees, but primarily in housing units. These policies that I've referenced, there are a lot of recommendations, but even the requirements are requirements with the caveat, if possible. And so enforcement, is always a concern. One of the things that's of great concern to me is where they seem to be especially non-expressive concerns testing. The screening is largely by quarantine, frequently in congregate settings, but testing specific for COVID-19 is a fairly recent phenomena. And you can see by comparison, I just have a couple numbers here. The BOP, which is the Department of Justice's Bureau of Prisons for federal prisoners, several weeks ago had already reported 337 positive cases amongst its population. The New York City Department of Correction, which is a city jail system, had reported several weeks ago 287 inmates, and by some reports that has more than doubled in that period of time. You have Cook County, which has made the news recently in Chicago, and they've reported over 350 positive findings for the inmate population. In comparison, just a week ago at ICE, they had indicated 37 detainees had tested positive, and I checked again this morning, and it's up to 89, but in comparison to all the other systems, it's very low. And I don't believe it's because there aren't positive cases. I think it's reflective of that they were behind the other systems in testing and are still not testing very many people. And that, of course, as we've heard from the compelling presentation by Dr. Marty, has all sorts of other implications. On March 18, ICE had made the first of several population management announcements so as to flatten the curve. At that time, they said that they were going to refocus or fine-tune their focus on enforcing public safety risks, individuals who presented public safety risks, as well as those who were subject to mandatory detention. But as most of us know, that's virtually the whole universe of individuals, especially because of this exceptionally broad definition that ICE has adopted over the last several years as to what criminal grounds constitute. And that, again, are folks that could have even been tested for something. I'm just going to move real fast from there to say that in the most recent efforts, they identified, or they set as a goal that they'd like to reduce their current capacity to 75%. And as we know, in many places, they're well over the 100% right now. The one means that they have of suggesting that that occur is by focusing on individuals who they've identified as being at risk, as some of the rest of us have noted. That's not going to get us there. And I'd like to just leave for the moment with this suggestion that we really need to be approaching this by looking at reducing the input from the front end, reducing the number of admissions. We need to be giving serious consideration to the average lengths of stay and the conditions under which during that stay, whether it's the 55 days today or gets shorter. And then we really need to accelerate the releases. And this is a place where the correctional systems have really excelled. I know that I'm up at my line, but if I could just take another minute. A couple examples of how systems have reduced admissions on the front end. King County and also the Washington Department of Corrections have made extraordinary strides. King County and the state system both no longer arresting or detaining individuals who have technical violations of probation and parole, which you know are huge numbers. New York City DOC, which of course is struggling right now, has already discharged over 1,600 low-risk inmates, which has really reduced their population. Others are accelerating early releases. California DOC has already paroled 3,500 nonviolent offenders with 60 days that are left. There's so much that ICE could do to alleviate the crowding as well as to improve the sanitation. And top amongst that, just as I talked about the 55 days, when individuals are assigned to alternatives to detention, they stay there an eternity. The average length of stay at present is almost 2 years, 666 days. And so there's no point in moving someone from one system to another part of the system where they are then lodged. This is not what alternatives to detention were intended to do. They were there to be used as a staging to release to the community. We have so many low-risk individuals that are doing so well under these circumstances. I would really encourage ICE to rethink the whole continuum of control and to accelerate it from start to finish.
Thank you, so important. All right, Fermin, you wanna give us a taste of what's happening on the West Coast and on the ground?
Certainly. So hello, everyone. Well, first I want to thank all the other panelists for your insight and valuable information. And I'm very pleased to be on here sharing some information with y'all. So my name is Fermin. I'm a senior staff attorney at the IJP. So I'll talk a little bit about the problems with ICE detention on the ground, some challenges for lawyers and efforts to seek releases from detention. So first and foremost, just to to piggyback from what Fatma said, USCIS right now, they've closed in-person services until May 3rd. EOIR, which is the agency that conducts court hearings, has postponed until May all non-detained court hearings. So right now what we're seeing is detained matters, right? People in detention. I can share that this week, Otay Mesa court has closed. EOIR, these standing orders that were mentioned by Fatma earlier, and the operations of each court vary by jurisdiction. But Otay Mesa right now is closed. Currently, it has the most confirmed COVID cases in the country out of all the detention centers. Last time I saw, which was this morning, was 17 confirmed cases in Otay Mesa. So for those reasons, the court has closed. That's what we're seeing right now for practitioners in Southern California, particularly San Diego, that Otay Mesa has closed, and all filings have to be forwarded to the San Diego non-detained immigration court. For right now, that also means that hearings for detained folks are also being postponed at Otay Mesa specifically because of this court closure. At this point, there's no clear indication as when it's going to reopen, and that definitely brings some concerns to practitioners as to when their hearing is going to actually be held, when their matter is going to be concluded, because some of these folks are not eligible for release from detention. So certainly that is one of the challenges we're seeing as of this week with the court closure. This is, again, in line with the fact that it has the most confirmed cases. So whether or not this is going to happen to other jurisdictions and other detained courts, that's an open question. If there are more confirmed cases in other detention centers, and certainly those courts may also close. And again, that brings forth the question, when are their hearings going to go forward? Because as of right now, Otay has been postponing cases in chief. And I say cases in chief because bond matters as of today appear to be going forward. So that's definitely one of the challenges. One, just knowing when the case is eventually going to be heard in detention. And two, as Fatma mentioned, client visitation. Many attorneys, including myself, are not willing to go into a facility that already has 17 confirmed cases, particularly when we've seen perhaps measures that don't convince us that we will be safe from contracting COVID. And definitely, I take the personal stance that health and well-being takes precedent over other obligations, but certainly those other obligations are important to meet as well. So we're stuck between choosing between our health and representing zealously our clients. And I don't think this is a situation we should have to choose. Or rather, this is not a decision we should choose, right? We should definitely zealously represent our clients, but also maintaining health and well-being for us, also for our other clients. So certainly that's a challenge we're seeing. As Fatma mentioned, not every attorney has PPE and equipment to conduct in-person visits. And also because of the asymptomatic nature of this virus, we don't know if we're carrying the virus and if we might infect our client in an in-person visit. And again, that brings forth the issue with remote preparation, right? How do you adequately remotely prepare a case? As Fatma mentioned, video visits are possible in these detention centers, but they're not necessarily confidential. There may be other detainees around, and there may be other staff from the detention center around, which really brings forth the concern as to whether we're having true confidential communications with our clients. And that's something that should be honored at all times, whether or not there is a pandemic. Confidentiality is an important tenet of the attorney-client relationship. It should not be compromised in light of this current situation. And for those reasons, those are concerns that practitioners have ran into. In terms of release plans, as I mentioned earlier, bond hearings are going forward. Those fortunate enough to be eligible for release from detention in front of an immigration judge can still do so as of right now. However, not everyone is eligible for release, and not everyone has the luxury of having their case heard in front of a judge. So I will say that people in detention can all be released under ICE's authority. So ICE has the authority to release individuals in immigration detention. Whether or not they'll do it is an open question. They've recently issued some guidance as to who might be eligible for release, including people who are at high risk, you know, those who are 60 or older, those with underlying health conditions. And we have seen certainly that those individuals are prioritized and their detention status is reassessed. So there's some good news in some respect, but as far as a clear procedure, apart from your typical parole request, that has been absent from ICE. So that's certainly a challenge. Practitioners such as myself reach out to deportation officers to see whether or not they will be inclined to release certain clients. And certainly that is part of the work and part of the challenge in representing folks in detention. And lastly, for people who have exhausted all of their remedies, right, and people who have gone in front of judges and people who have tried with their deportation officers, certainly another avenue is habeas petitions with their respective district court. And particularly considering the fact that detained hearings are being continued, this brings forth the question as to, is their detention going to be indefinite, right? When are courts going to go back as business as usual, correct, as the status quo? And if detained folks are held with no finality, especially before a removal order, that brings forth the question as to, are they being held indefinitely? You know, legally speaking, folks in detention can only be held until the removal proceedings finalize, or whether they're a danger to the community, correct? And if there's no end in sight, if the courts aren't hearing their case and there's no movement on their cases, certainly this is a question that should be brought to a federal district court as to whether or not this is lawful detention. And I say this, that this is a possible avenue that some practitioners may be inclined to take, but there's no clear answer to that question, right? This is something that requires advocacy and creative thinking, which is part of the work that many practitioners, such as myself, do. But overall, these are just some of the challenges, right? As Fatma mentioned, remote preparation, no clear, date of when courts will resume normal operations, and it's a day-by-day thing. And practitioners have to go online, see what has changed, and adapt. This is certainly a time where we've seen a lot of practitioners adapting to day-to-day situations, and that's going to continue for the near future, I believe. So as far as that goes, my only advice would be to make efforts, right, exhaust all avenues, and adapt to the ever-changing environment, because that's the best we can do during these unprecedented times.
Thanks, Fermin. And just to follow up on what you were just mentioning in terms of habeas litigation, probably many of the participants know, but there have been several larger class action or group-based impact litigation matters filed really in courts almost all around the country, sort of starting on the East and West Coast, but now some in Texas and Louisiana and elsewhere, with mixed success, but certainly with some success in particular cases. And those litigation matters raise a number of considerations. One is sort of the possibility that at least particularly medically vulnerable individuals who are forced to stay in detention in situations where they could easily become ill and would not be properly cared for would be facing violations of, it has to be treated as a Fifth Amendment substantive due process situation, just given the uniqueness of immigration detention. Also, broader than that, in some cases, some courts have found that just in general, regardless of medical vulnerability, that because this is civil detention, which, as you mentioned, Fermin, is supposed to be very limited in nature, only use this deprivation of liberty where necessary, where the government has some need to detain in order to prevent flight risk or danger to the community, and given the kind of other side of the balance of likelihood of illness and lack of strong showing of need, that basic fundamental liberty interests under substantive due process should also lead towards release. And then there have been some cases that have largely been based on the attorney access question. The idea that if you can't access an attorney, which of course is not provided at government expense at all in the immigration context, we should be very clear, I think that's been raised, but that might lead to another set of violations that would make the deprivation of liberty impermissible. So I just wanted to make sure people are thinking about those possibilities. Okay, so we only have about 15 minutes left, and we want to give every one of our amazing panelists an opportunity to give us kind of a last word or last recommendation. But we do have a couple of questions. I'm not going to go with the kind of preset questions, although and many of those issues have already been addressed anyway. But there are a couple of questions from participants that seem worthwhile to touch on. If we can do that kind of really quickly, I'll pose those to particular panelists, and then we'll move to making kind of a final comment or recommendation by each of the panelists. Dr. Marty, are you available? Oh, great, you are still here. So one question that has been raised is from a medical perspective, these efforts to close down borders, which of course have the effect of not really getting rid of the problem, but of sort of reshuffling it in the case of the Mexico border, US-Mexico border, leaving people in encampments in northern Mexico or forcing them to try another country to seek asylum, as Alice mentioned. From a medical perspective, what is the effectiveness or the wisdom of sort of trying to shut down borders? If you can help us think about that for a minute.
Well, it's a challenging question, because bottom line is we're trying to limit human-to-human transmission, so we're trying to limit close contact. But, and by the way, I absolutely loved every single one of your presenters. I love all the legal aspects of this. And this right to being able to come into a country plays right into that. I think that from a medical perspective, it's more about being able to do this in a way that limits human-to-human transmission, limits secondary infections among close contacts and staff, if there is staff involved, so that people can enter and make their claims, but in an optimal setting where you have optimal prevention and control, infection control strategies, where the inmates would have, or individuals would have access to quality of care, beds, and beds placed in such a way that people are separated by at least 6 feet when they sleep, access to PPE at the appropriate level, having a sense of medical readiness and response plans in the detention centers. That's the way we look at it. Do they have access to the things that are going to decrease their susceptibility? Access to good quality food, exercise, sleep. And that access to food has to be done in a staggered way so that you don't crowd people in when you're feeding them. Anything that keeps people apart and safe while you're still conducting the normal activities is fine. You, of course, want to protect the vulnerable. You want to identify those people that from age or underlying conditions should be in a separate zone. You absolutely should not scapegoat or stigmatize anyone simply because they're trying to escape a horrific situation. And we should, as humanitarians, also take that into consideration. So I think this is a multifaceted problem. From a medical perspective, it can be managed, but we have to think through what we're doing.
That's amazingly helpful, particularly given that the alternative sometimes to the organized processing is in fact much contact, as is existing in an encampment in Matamoros, Mexico, for example. Alice, I was going to turn to you, and it looks like you have something you wanted to say in addition to whatever comment you might have on that. Several of the participants asked what UNHCR is doing, can do about specifically some of the responses, and I know you may have to speak to general guidelines rather than to specific discussions that are taking place with the U.S. government. But if you could speak to that question of what can UNHCR do to make sure that the guidelines are being followed?
Sure, absolutely. So I think Dr. Marty made some very good points about ways that you can effectively quarantine people when you do have to restrict their movements. And I think that ties very nicely to Dr. Schreiro's points that another really good option is to get people onto alternatives to detention as soon as we know that it's safe and feasible to do so. UNHCR is working with a number of the UN agencies to for a massive appeal to our donor governments. And we have been actually getting some quite good results from donor governments, because I think there's a big concern globally about camps like the Matamoros Camp, which is, for those of you who don't know on this call, it's a camp of, I believe, somewhere between 1,500 to 2,500 people just south of the Brownsville port of entry at the US-Mexico border. It's very cramped, very chaotic, very difficult to imagine any sort of infection control. That camp is not actually an official refugee camp run by UNHCR or any one of its partners, but we do run camps in other parts of the world, and we also work with refugees who live in very cramped settings in urban populations in many, many parts of the world. And I think there's an enormous concern about how difficult it is to control the virus once it goes into that kind of setting. And so the more people are getting backed up at borders without real plans for how to deal with it, the more that is just a very realistic concern. And so we've launched this appeal, which, like I say, is about half funded at this point, which is great. And we're working very closely with WHO and with some other parts of the UN system to try and rapidly increase the public health availability and framework for response in those kinds of places, working with colleagues like Dr. Marty and the kinds of pragmatic solutions they suggest to how we actually even begin to address the needs of some of the most vulnerable people in the world at this point.
Alice, do you know whether testing is happening at the US-Mexico border? COVID-19 testing.
So I can answer that in what I know from reading press reports. We haven't done any independent monitoring of that. I understand that the CDC, under the CDC order that it issued on March 20th, has the authority to do that testing if they want to. I understand it's not going ahead in lots of the cases that are being sent back. So when the expulsions are happening, there certainly is not a routine testing for COVID at that point. We also know from press reports that some of the deportation flights from the United States to Guatemala have seen some quite worryingly high rates of COVID on those flights. There was one particular flight where about 70 people were on the flight and about 49 tested positive for COVID. I saw Dr. Marty's eyebrows go up there. I'm not entirely sure as the accuracy of the kind of testing the Guatemalan government is using once they receive flights of deportees and that sort of thing. So I guess my answer to your question, Denise, is we know that there is some sporadic testing going on. We know that there is authority to test, but we don't think it's in any way kind of systematic and reliable.
Dora, Dr. Schreiro, if people were released from detention, where would they go? How do we know that they would appear for hearings? And is there anything that ICE could be doing differently in this crisis to ensure safer, more humane treatment for those who are in the detention system?
Definitely. Oh my gosh.
Yeah,
you know, there's a whole continuum in it, and it's all based on objective, reliable risk assessments norm for the population. You find out who you have and what it is that they need to be successful. You do that when they're in the detention facility. You know who belongs in a dormitory versus who belongs in a cell. And it's really no different when you're thinking about, well, who can we move to the community, or who can we start immediately in the community? under what terms and conditions. The one thing to recall is that assessing on a periodic basis is especially useful because all of us go up and down and back and forth in the course of a year or so, and the same is true for this population. In general, we know that people do well under the least restrictive means possible. When you have a low-risk individual and you try to manage them or over-manage them, it usually has an untoward result and it costs a pile of money, both in terms of the unnecessary supervision that you're providing and then the consequences that emanate as a result of that. This is a time for increased transparency and accountability, and for ICE to be able to report on an ongoing basis some clearly defined objective measures of how we're doing for people who are inside, and how well are they, how many are being tested, what are the results, how many are being moved back to the community, how many require some special medical intervention, either in the facility or off-site. All of this is exceptionally important. A place where ICE should double down is planning. The situation that they're in today is because they still largely are working with facilities that others propose to them. They need to adopt their own vision as how a whole system should work, from the community in the least restrictive setting to a facility in its most restrictive alternative. And it needs to then acquire all those assets and deploy them in a thoughtful, evidence-based way.
Thank you. Fatma, what did the immigration judges say about all of this? That's a question. What about the National Association of Immigration Judges particularly? We can't hear you. Unmute.
Sorry about that. Yes, I saw that question. So yes, the National Association of Immigration Judges and AILA, which is the American Association of Immigration Attorneys, have called on the immigration courts to close. So I think the judges are very afraid for their own safety. Many of the judges are older, not by no means all, but and there have been, they're at the greatest risk because they're in the court all the time, in courtrooms that are full. So their position is that, at least their union's position is that the court should close.
Thanks. Okay, so we're going to start our lightning round of kind of final recommendations with Fermin. Fermin, and I don't mean to put the pressure on you, but if you may be the only one who's in a decent position to answer this question, it's okay if you're not. There were a number of questions about non-removal proceedings as well, SIJ cases, affirmative asylum cases that have already been interviewed, cases that may not potentially DACA need interviews at all. If you have any insights that you want to share about what can be expected with those, that would be great. We know that the USCIS interviews have been shut down for the time being, but some of those paper applications, I believe, are going forward. But more importantly, share with us what your kind of biggest concluding thought or recommendation would be as to how we should handle this crisis.
Right. So you're correct. Interviews are being postponed sua sponte, so on their own accord. But my recommendation is, if you do have relief you want to apply for, make your best efforts, especially if you have counsel, to mail the applications, work with counsel and file those applications as timely as possible. While there may not be immediate action on them, you do want to keep a paper trail that you made efforts to apply for relief, considering that some of them do have very strict deadlines. So the best I can advise is, try to resume as normal as possible and make efforts and document those efforts.
Sorry about that. Fatma, any concluding remarks or recommendations?
I think my strongest recommendation would be about the right of access to counsel, and that if that constitutional right cannot be protected, then I don't think I should be, for that among many other reasons, I should not should then have to not be able to detain people that cannot provide confidential access to counsel.
Great. Alice, any concluding thoughts?
I think am I unmuted? Yes, good. I think my concluding thought would be that our best option is for governments to work together to try and come up with different solutions on how to manage borders, because each government by itself tries to set in place some sort of survival mechanisms will land nowhere with immigrants and refugees.
We're seeing that even internally in the United States with state-to-state measures. All right. Dr. Shapiro, what is your biggest recommendation for how to go forward from here?
Well, let's remember that detainees are people, and they're behind those walls, and many of them don't have a to phone or mail, and most don't have attorneys. It's really important for the facility to keep them informed, have them involved in their own care and treatment. They are fearful, and they have reason to be, and communicating with them can go a really long way.
Sorry, I had myself muted. Dr. Marty, do you have anything to leave us with in terms of wisdom, advice, recommendations, conclusions?
I just want to add that we have to communicate properly in the appropriate language to all these people. Good communication, appropriate risk communication, honest communication, which is lacking at certain levels of leadership in certain countries. Is counterproductive. And yes, I agree with those who say that we should work with the leaders of other countries, but the leaders of other countries are part of the problem in some instances, and why we're seeing people immigrating here. So it's a very challenging situation, and I think the strategies, the policies, the plans have to be considered very, very carefully, and with a good heart, as well as good science base for what your decisions are.
Oh my goodness. So many participants have already commented on how rich the expertise offered today was. And I really want to echo that. I just can't imagine a better group of people to enlighten us and help us to think through these challenging issues. It just seems like the conversations are so much more important than ever. And there's so much hunger for the information and thinking about where we are and where we're headed. So thank you to the panelists. Again, we will be sending out to everybody who registered links for recordings. Materials will be up on the website as well. So please do follow up after with that information. We really hope you enjoyed the webinar. I'll make a plea to engagement and support for the ABA Commission on Immigration and the Committee on Civil Rights, who mainly put this together. The Civil Rights Committee in particular is an open committee to membership, so there may be participants who would be joining the committee at this point and providing support in that way, and that would be greatly appreciated. All of the relevant information can be found on the American Bar Association website, which is the basic website is just americanbar.org. So thanks to all of the panelists once again, and to all who participated as well. It was really meaningful. Thanks so much.
Thank you.